Landlord retaliation is one of the most legally dangerous mistakes a property owner can make, and it's more common than most landlords realize because it can happen unintentionally. What counts as protected activity? Tenants are protected when they report code violations to housing authorities or building inspectors, when they complain to you in writing about habitability issues, when they organize with other tenants, when they exercise any right granted under their lease or under landlord-tenant law. What counts as retaliation? Raising rent after a complaint, threatening eviction after a complaint, reducing services, restricting amenity access, being slow to make repairs after a complaint, filing for eviction after a complaint. Any adverse action taken in response to protected activity. The presumption problem. In most states, if adverse action occurs within 60 to 90 days of a tenant exercising a protected right, the law presumes retaliation. You don't have to prove intent. The timing creates the presumption, and the burden shifts to you to prove your action had a legitimate, independent reason. How to protect yourself. Document your business reasons for every action independently of any tenant complaints. If you're raising rent at renewal, have a market analysis. If you're issuing a notice, have a documented lease violation record. If the timing of any adverse action coincides with a tenant complaint, document why the action is unrelated. Never, under any circumstances, react to a tenant complaint with anything other than addressing the complaint. Let the complaint be investigated and respond professionally. TenantScreeningBackgroundCheck.com. A well-documented tenancy from day one is your best protection.